Good afternoon. I want to run through my information for Chapter 1. I will be posting subsequent videos in the other chapters as I get them downloaded and ready to post. But as promised, I'm going to run through these as quickly as I can just to sort of hit some of the highlights of the chapters that you've read. Keep in mind that anything is fair game for testing. I anticipate that your test is probably going to include multiple choice and some essay questions. It will be online, as I've stated before, and I will post more information when it is available. So, Chapter 1. After reading Chapter 1, you should be able to describe the nature and scope of a contemporary family law practice, identify ways in which technology has impacted the practice of family law, describe the role of a paralegal in a family law practice, identify the major objectives of an initial client interview, explain why fee agreements and timesheets are important, list primary legal research resources used by family law paralegals, and identify basic ethical principles that guide the professional conduct of family law paralegals. So we're going to start with describing the nature and scope of a contemporary family law practice. What is family law? Family law is the body of law that deals with marriage, divorce, custody, adoption, support, paternity, and other domestic relations issues, including matters related to non-marital couples and family units. What are some of the characteristics of contemporary family law as it has evolved over the past 5 decades? These are all discussed in more detail in your text. I encourage you to take a look at them, but these are the primary characteristics of contemporary practice as it has evolved. So there is an increased focus on negotiation and alternative methods of dispute resolution, otherwise known as ADR. There are some courts, in fact, that mandate that parties at least submit to pre-litigation screening for mediation or other forms of alternative dispute resolution, mediation being the big one. And oftentimes there are couples who will attend mediation prior to even contacting attorneys or filing any divorce proceedings. So mediation is one of the primary forms of alternative dispute resolution utilized by people going through the process of terminating a marriage or determining custody rights of children, etc. There has been a decrease in litigation. There has been an increase in cost of litigation, but a decrease in litigation because of the use of alternative dispute resolution, and parties representing themselves often already have agreements before they step into the courtroom. So a decrease in litigation because of those factors. An increase in pro se proceedings. Again, pro se is parties who represent themselves. A lot of the increase in pro se litigation or pro se proceedings is because of all of the technological advances and all the information that is available online now. If you go to the Franklin County Clerk of Court's website and take a look at the Domestic Relations Division of the Common Pleas Court, you'll find that every form that you need in order to initiate divorce proceedings is there and available, downloadable, and parties can get those forms there and start the proceedings on their own. The introduction of no-fault divorce in the 1970s had a huge impact on the practice of family law. I encourage you to take a look at that section of your text again, just to look at some of the ways in which it sort of reformed the practice. A decreased focus on marital fault and spousal support in property division context. The courts really look at the assets strictly, the assets, the debts, and the financial status of the parties. They don't look at fault when determining those issues anymore, which is really difficult to explain to clients at times, especially when you've had infidelity, for example, and you have one client coming in very upset about the emotional aspects of the breakdown of the marriage, very upset about the infidelity, and really wanting to punish the other party. And it takes a while to get them around to the notion that the courts really don't care about that anymore. The courts are not there to judge parties' ethics. They're there to divide assets, to allocate parental rights and responsibilities, and to determine who gets what property. So what property and what debt. So the no-fault divorce and the decreased focus on marital fault when determining property division and spousal support has really had a tremendous impact on the practice. And it's been such a recent change that parties that have been married for a number of years are still surprised that the courts don't look at those issues in the way that they used to. So it does take some time sometimes to get clients around to that, to accepting that idea. Increase of federal involvement in some areas of substantive family law, such as child support. Differences and changes with the parties. There is an increase in divorce and cohabitation. Parties living together without getting married. So that has definitely had an impact on divorce per se, because non-married parties don't need to go through a divorce. Increase in divorce in general between parties who are married. We've all heard the statistics. So the increase in divorce has been a change as well. Increase in autonomy for individuals to negotiate their own terms and agreements, premarital, cohabitation, separation agreements, etc. Parties are really more empowered now than they have ever been before, with all of the information that is available to them that previously was not available really by any means other than contacting an attorney. You've got all of these resources, all of these forms, all of these things that are available online now that really make it more palatable for people and more understandable, so that they are able to get through the process on their own in many circumstances. Recognition of marriage as a partnership with economic and non-economic contributions made by spouses. So when you look at circumstances with a stay-at-home spouse or stay-at-home parent, the contribution of those spouses is valued, I believe, more now than it was in previous years. And they really do view marriage as more of a partnership, and that those decisions, as opposed to penalizing one of the parties for being a stay-at-home parent or not being out in the workforce, it really is viewed as more of a partnership, and that was a joint marital decision. And so they're not going to penalize the party who was the stay-at-home spouse. They're going to make allocations for spousal support, things like that, to allow that party to increase their ability to get back into the workforce and be self-sufficient. Recognition of equal rights to custody if fit parents. So it had previously been sort of the generally accepted notion that mothers had a preeminent right to custody of the children, because typically it was the mothers who were responsible for the raising of the children, at least in the eyes of the court, and keeping with sort of the societal conceptions of family as well. It's now considered more it's now considered more equally, and courts really do tend to favor shared parenting for that reason. They consider that that again was a joint marital decision, who was going to stay home with the children, and that the parent who was out working and not responsible for really the day-to-day raising of the children, if that is the circumstance, is not going to be penalized for not having been there with the children. Courts really want to give parents an opportunity to parent, so shared parenting really is the preferred method of dividing parental rights and responsibilities if both are fit parents. Increase in custodial rights for third parties, talking about grandparent visitation, etc. Shift to alimony as gender neutral, as opposed to what we used to consider alimony or spousal support. The general conception was that it was the wife that was the recipient or the payee, and it was the husband who was the payor. Expansion of the definition of family. Obviously, we have non-married parents. We have situations where we have same-sex parents. We have a same-sex family where one party contributed genetically to the child, one party did not. So biologically, there's a familial relationship there, but there's also a recognition of the other parent, in quotations, I guess, for purposes of our discussion, and more recognition that those are valid relationships that should be recognized and rights given to protect those individuals. Recognition of same-sex relationships in a number of forms. Increase in the use of assisted reproductive technology. Let's take a look at identifying ways in which technology has impacted the practice of family law. General impact: technology has changed ways in which law firms create, obtain, store, and retrieve information. The paperless office looms on the horizon. Digitally stored data has proved to be more convenient, accessible, compact, and transportable. Members of the family law team must be aware of advantages and disadvantages of technology. Several courts now manage dockets electronically and permit electronic filing. Some, in fact, mandate electronic filing, so know the rules in your jurisdiction. Electronic data is discoverable, so things that are stored on your hard drive are discoverable. Things that are Facebook posts are discoverable. Things that are out there in cyberspace are all discoverable. So make sure that you are aware of your clients' sort of digital shadow, as well as accessing the opposing party, because all of those things are discoverable and usable in litigation. Parties are obligated to maintain electronic data. Computer forensics experts are used more often. Software products are available to manage all aspects of office management. If your firm utilizes practice management software, get to know that software well. There are many things that software can do to automate the office to make your job a lot easier. So utilize the software that's out there, get to know it. If you are not yet with a practice, familiarize yourself just generally. Do a Google search for what are some of the more prominent legal practice management software programs, and see if there are YouTube videos or online tutorials that you can take a look at to at least familiarize yourself with the basic platforms, so that you know how most of them tend to function in a similar fashion. So get to know those programs the best you can, even if you're not in a practice yet. Office websites are a key component of marketing a firm. Forms, statutes, and cases are now available online. PowerPoint presentations may be used during negotiations, hearings, and trials. Email is replacing snail mail to some extent, and related policies need to be established and observed. I know that Columbus State offers a number of programs, or a number of courses for training in different software programs. Take those courses, even if it's an online course. Familiarize yourself with the different platforms, the different programs that are out there. Those are things to, if you've taken a course in the Microsoft Office suite, for example, or any of the programs attendant there too, put that on your resume, put it in your cover letter as additional training. Make sure that those are skills that your potential employers know that you have. Familiarity with the different technological platforms is definitely something that is valued by employers. Describe the role of a paralegal in a family law practice. A paralegal or legal assistant is a person who, through formal education, training, and experience, has knowledge and expertise regarding the legal system and substantive and procedural law, which qualifies him or her to do work of a legal nature under the supervision of an attorney. A paralegal's role in a firm varies based on a variety of factors: the size of the practice, the scope of the practice, the skill of the paralegal, the style and expectations of the supervising attorney. What I'm going to tell you about this is to know what your responsibilities and your duties are, to make sure that those are clearly defined, and that you know what the expectations are. If you are in a small practice, for example, and it is one attorney, you may be performing, and you probably will be performing, not only paralegal work, but also secretarial work. If you're in a large firm, you may be more specialized. You may be doing research and writing. You may be a discovery paralegal who handles only discovery matters, getting requests for information out, getting those documents back in, making sure that we comply with discovery requests that are given to us, and that we get documents to the opposing side in accordance with the rules. So know what your job description is, know what your responsibilities are, and know the style and expectation of the supervising attorney, because attorneys are going to vary widely in their expectations of their paralegals. I, for example, and I will rely on my paralegals heavily with respect to drafting form documents and things of that nature. If it comes to an appellate brief, while I know that the paralegals are trained to do research and writing, the appellate briefs are something that I do on my own, because it helps me to formulate my argument and to be able to anticipate the arguments of the other side. So know the expectations of your supervising attorney. Tasks performed by family law paralegals commonly include completing office management tasks, scheduling, billing, filing, etc. I'm going to tell you, scheduling is very, very, very important. Some offices still rely on paper calendars. Some are strictly digital calendars, online, phone-based, whatever their program is. Some are a combination of both. It is very, very, very crucially, vitally important that scheduling is a matter that's taken very seriously. If we miss court appearances or anything else, it is disastrous for the firm, for the reputation, for the reputation of the firm with the courts as well as with the clients. So scheduling is very important, as is billing, filing. All of these things have to have you must have a strong attention to detail. Make sure that these things are done consistently and accurately. You'll also be drafting correspondence, participating in interviews, locating governing laws, statutes, cases, rules, administrative regulations, and forms, drafting documents such as complaints, motions, affidavits, trial memorandum, etc. Maintaining communication with the client, very, very, very important. One of the biggest complaints that law firms and attorneys get is that the client couldn't communicate with them, didn't feel as though they had enough communication with the attorney. So it is important to pick up the phone, make that phone call. I know that it is time consuming, but it is crucially important that the client feel as though their concerns are heard and they have adequate communication with their attorneys. And researching legal issues, very important part of a paralegal's job. It's what sets you apart from a more secretarial or administrative function. It is your training and your expertise, your ability to do that legal research and to be able to understand and comprehend what it is that you are reading. Identifying the major objectives of the initial client interview. If you are a paralegal who's going to be conducting client interviews, I strongly encourage you to ask your firm or your managing supervising attorney if you are able to sit in on some client interviews before they put you in there. Now, sometimes the attorneys will have a paralegal sit in, and sometimes the paralegal will do an initial, what we call interview, just getting some basic information from the client. So the major objectives are to identify the client's need for services. Is the client looking for, is this a post-decree? They're looking for a modification to a pre-existing order. Is it a divorce? Is it a case that might be more amenable to dissolution? What are the client's needs? What are they there for? What is their ultimate objective and goal? Discuss their goals and their expectations. What are they hoping to get out of this? What is it that they want to accomplish in the end? Determine whether the client and attorney will establish a relationship. Can the attorney accomplish the goals that the client has set out that they want to accomplish? Is the client comfortable with the firm? Do they want to move forward? Discuss the scope of representation and potential fees, cost, and payment terms. Typically, this is going to be something that's done with the attorney, but again, if the attorney has you sitting in, these are things that are going to happen in this initial client interview. Introduce members of the team in their respective roles. Are there managing partners? Are there associates? Are there law clerks? Other paralegals who may be working on the case? It's important that the client feels like they know who's in the office, who's going to be working on their case. Discuss the nature and scope of attorney-client confidentiality and privilege. Identify any urgent issues or deadlines. Gather basic intake information. Agree on a course of action and a follow-up plan. Explain why fee agreements and timesheets are important. They are vitally important. There are a variety of different types of fee agreements that are used. They're laid out in your book. Contingency fees are generally not permitted, though, in family law. There's a trend towards unbundling of legal services. Letters of engagement and non-engagement help reduce misunderstandings and malpractice actions. Very important in the letter of engagement to spell out what, and in the fee agreement to spell out what it is that the attorney is going to be doing for the fee provided. And the non-engagement letter is very important for pointing out in subsequent disciplinary actions or malpractice actions when the attorney-client relationship terminated. So that non-engagement, I'm sorry, let me back up a second. Not the non-engagement letter. The non-engagement letter is going to be that we are not going to be representing you for whatever reason, so that the client understands that there was no attorney-client relationship that was established. Disengagement letter is what I had started to talk about. Disengagement letters are sent at the closing of a case when the representation is finalized. The disengagement letter is the crucial document in determining when the legal representation terminated for purposes of statute of limitations for malpractice actions. Billing and fees are a major source of malpractice actions. Fees charged must be fair, reasonable, and documented. I know that it is a hassle. However, it is important to keep good records of all of the time spent in a case. Even if your firm ultimately determines that they're not going to bill for that time, it's important to keep track of your time for purposes of the client and also for purposes of subsequent performance reviews that may come up if you are required to bill a certain number of hours. So keep good time records. Very, very important. Characteristics of an effective fee agreement. It's executed at the outset of representation. It is written in plain language and translated into native language of the client if necessary. It clearly describes the scope of services to be provided and in some instances not to be provided. So you would spell out in that initial fee agreement that this is for the domestic relations case or the divorce case at the trial level, and any appeals or subsequent post-decree actions are not included in this fee agreement and will require an additional retainer. So it's very important to spell out what those services will and what services will not be provided. It specifies the fees to be charged for members of the family law team working on the client's cases. So it specifies what the attorney's hourly rate is going to be, what any associate attorneys or law clerks' hourly rates are going to be, what the paralegal staff rates are, what the support staff rates are. It identifies costs that the client is responsible for paying, such as travel, postage, telephone, copies, etc. It identifies conditions that may trigger termination of the agreement, so non-payment of fees, something to that extent. List primary legal research resources used by family law paralegals. If you have taken my legal research and writing course, you are by now hopefully familiar with some of the legal resources that are out there and available. These are going to be the primary resources that a family law paralegal would rely upon. So statutory codes. What's your state statute on spousal support, child support, division of marital property, etc. Court rules. Very, very vitally important to be familiar with your local court rules. They are not uniform throughout the state, so it's very important to know how the courts operate in your particular jurisdiction. Case law. Practice manuals, form books, legal dictionary, citation manual, and legal newspapers. Identify basic ethical principles that guide the professional conduct of family law paralegals. Ethics are standards or rules of conduct to which members of a profession are expected to conform. Ethical rules or canons are often laid out in professional rules of conduct for attorneys and for paralegals, such as the ABA model rules for attorneys adopted in most states in one form or another. There's also the National Federation of Paralegal Associations, the NFPA, and the National Association of Legal Assistants, NALA. They have their own canons. Some of those are in Appendix A of your textbook, so take a look at those. Attorneys may be held liable for the acts of their paralegals performed within the scope of employment under the doctrine of respondeat superior. The ABA has model guidelines for utilization of legal assistance for the reference of supervising attorneys. For a basic summary of paralegal ethics in a nutshell, you can take a look at the information there, the basic do's and don'ts on page 15 and 16 of the textbook. Major problem areas encountered by family law paralegals include the unauthorized practice of law. Take a look at Columbus Bar Association v. Thomas. We've talked about that in the discussion board. Conflicts of interest, breaching client confidentiality. We also talk about this in the Intro to Paralegal Studies course if you have already taken that, which most of you have. All of you have, I would assume. But again, some of those things are spelled out in that course and also in your text. The attorney-client privilege. It is established by statute. It refers to the client's right to refuse to disclose and to prevent the attorney from disclosing confidential communications between the client and the attorney unless the communication concerns future commission of a crime. So the attorney has the ability to disclose confidential information in order to prevent harm to someone else or to the client. And there are certain other circumstances. If the client is suing the attorney and the information that was gained during the attorney's representation of the client is pertinent to the suit against the attorney by the former client, some of that information can be disclosed as well. The rule of attorney-client confidentiality is established in the rules of professional conduct. It refers to the duty of an attorney to not reveal information relating to representation of a client, subject to limited exceptions. This rule extends to everyone in the office. Do not discuss cases outside the office ever, period. End of story. Not really a gray area there. It's best just to not, whatever happens in the office stays in the office. It's best to not disclose those things, telling war stories or anything else. Even if you're not specifically referencing the client by name, it's best to just keep that information within the firm. So that is chapter 1. I hope that you found the presentation helpful and will tune in for the subsequent videos. Again, I will be posting more information about the about the midterm as we get a little bit closer. Thanks a lot. Bye-bye.